themselves for the record, starting with prosecutor.
Blair Lockman for the TV runner.
Deborah Benedicto, Dr. Pittman.
Michael Anderson on behalf of Mr. Pittman as well.
Okay, good morning. This is the date and time set for sentencing in this matter. Mr. Lockman, is there anything from the people before I proceed?
Yes, Your Honor, I'm gonna say something, but I believe the family is also they're on the elevator coming up and they do want to address the court as well.
Okay.
So I'll go first and then, the family. Your Honor, the only, thing that I wanna point out is, reference this sentencing memo created by the defense, in discussing the facts of the case and why he did what he did. There's a couple of things I just wanted to note. Number one is, we have never received or seen any single evidence that this alleged shooting early in the day took place. No police were ever called to a shooting, no suggestion was made that there was a shooting, no reports were made of a shooting, which would be extremely rare in Grand Rapids. So I first will begin with the idea that that is speculative, unsupported, but the bigger concern, Your Honor, is based on the facts and the evidence, and obviously the court is aware that this is all on video. Now, one, I don't think Ms. Benedict-Notter meant to suggest this, but this suggests premeditation, that he sees these individuals whom shot him at earlier and made the decision to go after them and shoot them. Now, he says he did that because of fear or concern. The video is very clear. Number one, these individuals would never have known it was him. He was fully covered, his face and his head. So there's no way they could have identified him. They had no idea he was there. There's two pathways. They could not have seen Mr. Pittman to know he was there, to do anything to Mr. Pittman. There's no suggestion that those individuals even knew Mr. Pittman. And if you watch the video, you can see Mr. Pittman walk at a high rate of speed in front of the other individuals that were there, turn the corner and open fire. There was no exchange, there was no exchange of words. So number one, this doesn't show remorse. This shows anything but that. It's an excuse that is unsupported by any piece of evidence. It raises serious concerns that if he's not going to be remorseful for his actions, that he will be someone who, when he gets out, will do the same thing. It would have been just better if he just came up and said, "My bad, I shouldn't have done this." But instead, he's made up an excuse that is unsupported by any evidence, that shows premeditation, and ultimately a loss of the life of a 15-year-old girl who was looking at playing college basketball. She was a good student. She was well-liked and respected in the community, had never been in trouble, and she's gone. So for those reasons, we ask this court to sentence to the top end of the guidelines, which would be 25 years plus 2.
Great, thank you, Mr. Lockman. Is there anyone then who wishes to speak on behalf of the family?
Yes, Your Honor.
All right.
Hi,
Good
Your Honor.
morning.
Hi, y'all.
What's your name?
I am Shakita Matheson, College of Mine.
Okay,
I wrote down what I wanted to say. Is that okay?
that's fine. Go ahead.
Okay, I'm here today to share this tragedy that has deeply impacted my life. Since losing my daughter, LaKaja Williams, on May 18, 2024, my world has been completely changed. I've struggled from fear, anxiety, and overwhelming stress. What once was simple daily activities, working, sleeping through the night, feeling safe in my own home, now bring constant worry. I live with the ongoing fear for the safety of my other children. This tragedy has affected every part of my life. I've been unable to work and have developed health issues from this trauma. LaKaja's death did not only take my daughter, it shook my entire family. She was a loving big sister, big and little sister, a caring aunt, niece, and granddaughter. My other children are grieving deeply and live in fear that the same thing might happen to them. I lost my son in 2011 to unexplained death. And while the pain is unimaginable, the loss has been even harder to cope with. My daughter had so much life ahead of her. She was a talented basketball star. She loved helping helping her sisters with the children. She brought light into every room she entered. We will continue to mourn the loss of our sweet, loving anime. The emotional toll that is beyond words. A part of my peace, my purpose, and my joy was taken from me. I'm doing my best to rebuild, but healing from something like this takes time. I want the court to understand that the impact that comes from a crime like this goes beyond this day that it happened. It affects every single day. I believe in accountability and healing. I hope the person responsible understands the depth of the pain of their actions. That it has caused and is held accountable for their actions. I share this not out of anger, but out of honesty, to make sure my daughter's life, my pain, our family's experience is truly heard and remembered. Thank you for allowing me to speak.
Okay, thank you for your statement. Mr. Lockman, anything further from the people?
No, Your Honor.
Okay, in defense, I did see that there was a stipulation submitted with respect to scoring of the offense variables.
That is correct, Your Honor. We did stipulate to a correction of both the scoring of OB3, which should be corrected to reflect a score of 25 points, as well as OB13, which should be corrected to reflect a score of 0 points. That would reduce the entire OB score as well as the OB level and have a corrected guidelines range of 180 to 300 months.
Okay, and the people stipulated to this. The court has reviewed this and do agree. Mr. Lockman, is that the people's position on that?
It is, Your Honor.
Okay, thank you. Ms. Benedict Nodder, then are there any further additions, corrections, or challenges to the PSI or sentencing guidelines?
We have none, Your Honor.
Okay, is there anything you wish to say on behalf of Mr. Pittman?
Yes, Your Honor, thank you. I want to note, we did submit a sentencing memorandum in this case, and I want to be clear that if anything written in that memorandum reflected Mr. Pittman trying to make excuses or making light of his culpability in this case, that's the furthest thing from what was intended. There is no doubt, and it is certainly true, that what happened is an unimaginable tragedy, that it shouldn't have happened. And I want to note that Mr. Pittman is not offering his experiences or what was listed in that memorandum in an attempt to say that what he did was justified. In fact, the opposite. He pled guilty here, Your Honor, because he wants to take responsibility for what occurred on that night. It was given to the court and explained in an attempt to allow the court to know Mr. Pittman. With the proceedings until the plea, obviously the court is limited in terms of what it's exposed to with Mr. Pittman. But I would note that what the intention of that memorandum is to show that Mr. Pittman is a person who was a child in our community, who was raised in this community, who was subjected to incredible difficulty as a young individual, as a young child. He was deprived of having structure. He was deprived of having sort of that nuclear family at many stages. Like many children in Grand Rapids and in Kent County, he saw his parents being incarcerated. He saw days where he had no parent oversight. He was often moved from home to home. And we're not saying that to say in any way that what happened on that night is justified. But when you have a young child who is at a young age looking out his window and seeing a gunman try to shoot another person and then turn and put their eyes on him, when you're having a young person who knows that individuals that he is closely associated with are involved in gang violence and knows that because of his connection to those individuals that he is a target, that he has in fact been targeted in the past. It created an immense trauma mindset, to be quite frank, and it created a situation for Josiah where he felt like he was in a situation where he was in a constant threat of gun violence.
So how does it stop? How does the cycle, generation to generation, or at least in this case, and you have a young man who picks up a firearm and does the same thing. How does it stop?
Your Honor, I wish I had the answer.
Same here.
And I think the reality is, I don't know that any of us in this room can create a solution for that, can create an answer for that, but what I want to emphasize is that I've known Mr. Pittman for a year now since he got arrested on this. When I first met him, he was incredibly closed off. He was incredibly reserved. And slowly, over time, he opened up, and the first ways that he opened up was showing profound remorse. And if there's anything that I can say today, if there's anything I impart on the court, and I understand that Mr. Lockman has he's skeptical about that, and I think to a certain extent that's his job and that's his role here. And all I can impart upon the court is that Mr. Pittman's remorse is true. He has shown it to his defense attorneys and to his defense team profoundly. There is nothing that any of us can do today to bring back Ms. Williams, and I know if there was, Mr. Pittman would do it. There's nothing that we can do today that's going to improve the gun violence that we have in our community or in Grand Rapids. But what I think that the court can do is take into account that these are complex issues. It is a systemic cycle of gun violence, of children being exposed to normalized violence. And I'm not saying that this court should not impart a penalty. I'm not saying that this court should not sentence Mr. Pittman and give him a penalty for what he did, because that is this court's job. What I'm asking is that the court realize that there are children in our community who are exposed to things they should not be exposed to. That does have an impact on their psyche. It does have an impact on the decisions that they make. Mr. Pittman is not someone who I think wants to be a person who has done what he did, and he feels incredible remorse. I'm asking that the court take into account his youth, the child experiences that he did have, the frame of mind that he was in that day. And I'm asking that the court take into account his remorse. I know he gives a statement, has a statement that he wants to give, and so I won't go on for much longer, but I just want to say, Your Honor, the only thing I want to impart to the court is that this is a young man in our community who has experienced terrible things and made a terrible mistake and is willing to take accountability for that.
Okay, thank you. Mr. Pittman, is there anything you wish to say this morning?
Yes, sir. First, I want to apologize to the victim and the victim's family for the sinful act that I committed, causing them all great pain and suffering, emotional distress. Even though Akaja was not my intended target, I was wrong nonetheless for letting the devil take control of my actions on that horrible day. I'm aware I can never get her mother and her father and her daughter back, or put an end to the stuff that I caused. I am sorry. And though it is highly unlikely, I hope that Akaja family and friends can find it in their heart to forgive me for what I've done. I understand them fully if they refuse to do so, because forgiveness is a gift that I honestly do not deserve. I want to apologize to the prosecution judge and my family and the state of Michigan for my actions. I pray I can be rehabilitated while I serve the time for this horrible offense. May the family of Akaja be blessed by the grace of man in heaven. And hopefully himself guide me to become a better person for society. Lastly, I want to thank everyone in this honorable courtroom for allowing me to speak my piece today. Thank you. May God, the Lord be with you all.
Okay, thank you. Defense, anything further?
No, Your Honor, thank you.
Okay. Court is prepared to impose sentence. The court did receive the sentencing memo from the defense. The court's reviewed that and has taken that into consideration, but also I think the statement from the victim's mother is important as well in this case. Mr. Pittman, you pled in this case. You took responsibility for this. You pled to one count of felony firearm. That's a 2-year consecutive sentence. So you have to serve that first before any other charge, and then you pled to the second-degree murder. That carries a maximum penalty of life. At age 19, you have a juvenile court record, one prior misdemeanor. Your guidelines, you just heard, were corrected. So the correct scoring of your guidelines is 180 months to 300 months on your minimum sentence. And the COPS evaluation in this case is sentenced within those guidelines. There's a lot I probably could say about this. I think everyone kind of understands the situation. You know, gun violence that occurs. It seems like just daily, at least in this community, it's happening so often now. The question I asked you, Ms. Bennett-Nodder, I didn't expect you to have an answer, because I sure don't. I wish I knew. I wish I knew what compels a young man to pick up a firearm and to carelessly shoot it toward a group of people. I wish I understood that. And now, as a result, there's a 15-year-old girl who aspired to be a basketball star. She's now, she's dead. Her mom already lost a child before. No one should lose one child, let alone two. And it's just heart-wrenching. the community has to understand two things, I believe, as I sit here today. They have to understand, one, that there's accountability, and I think, two, they have to understand that the courts are doing what they can to make the community as safe as possible. So accordingly, Mr. Pittman, it's going to be the sentence of this court that you should be committed to the Michigan Department of Corrections to first serve the 2 years on the felony firearm. You'll get credit for 355 days you've served so far. Consecutive to that charge, you will serve a minimum of 300 months to a maximum of 600 months in the Michigan Department of Corrections for the second-degree murder. As that is consecutive to the felony firearm, you do not get credit for that charge. There are mandatory costs that the court has to impose. There's $136 state costs, $130 for the crime victims assessment, $1,000 in court costs as set forth in the judgment of sentence. This is the final sentence of the court. You will receive a form that will explain your appellate rights. Mr. Lockman, is there anything further from the people?
No, Your Honor.
All right, Ms. Panignata from the defense.
Just briefly, Your Honor, there was an adjournment, and so I think there is a short amount of credit
All right.
that's attributable to that
All right,
adjournment.
well, let's make sure we get that right. All right, so the original sentence date was back in September. So from September 10th to today.
That is correct, Your Honor.
Okay. Okay, I don't have that number offhand, I can try to calculate it now, but the judgment will reflect that credit. Okay,
Thank you.
all right, thank you. Yeah, from September 10th to October.
Yes.
Okay, all right, thank you.